D-minus 10, 9, 8, 7, 6, 5, 3, 2, 1, 0. Liftoff.
What is a Franks hearing? What does it take to make an effective chain of custody?
Today we have a lot of legal questions from our commenters. Andrew, do you have any answers for them?
I don't know. Let's find out. I don't even know what all the questions are. With all of the activity and hearings in both the Karen Reed case and the Bryan Kohberger Idaho 4 case, our commenters are paying close attention and they're asking us some really good legal questions. I'm attorney Andrew Myers.
And I'm Courtney.
Courtney, thanks for being with me today to go over last week's questions. And we have a lot of them and a lot of good comments that have come in to us through our channel. So why don't we just jump right into them?
At Bishop, is it possible that Hank Brennan could be working for the FBI? Maybe that's why he only accepted $75,000. Maybe it's a sting to get more insight of all the cover-ups.
I don't know. That would be crazy. We wouldn't know anyhow, but what do you think of that one?
I mean, it's a possibility.
The Norfolk District Attorney hired him as a special prosecutor, and then he's getting an hourly rate, and that's the cap. That's the cap on it. So that's why he can get up to $75,000, which I'm sure he will get.
Got it.
Okay. We had a great guest. We've had him on several times, Mark Betterow, and this is what our commenter, Sasha Bella, has said. You can't make this stuff up. Every day it's something new, and it gets more and more egregious with every new motion and Betterow letter. We are in shock, and we are outraged. The judicial system here in Boston has gone unchecked with dire results, while the whole world watches in awe. Mind-blowing. Great show. Love Mr. Betterow, as always. So insightful and on target with his knowledge about this ever-evolving case/trial. So, yeah, every time we have him on, we get a lot of great comments, and I think he's a great attorney also. He has been watching the Karen Reed trial closely, and I just think it's great that he gave us time to talk to us.
At Liz in the Bee. Even Reed knew that she busted her taillight. She told anyone who would listen. Yet the defense and the cult members are claiming her taillight wasn't broken. And spare me the she broke it when she backed into John's car in the driveway. That little love tap didn't do squat, and you all know it. Hashtag she hit him.
I love when people tell me that we all know it. No, I don't know anything. I don't know that at all. You know, when people tell you, like, you know it. No, you don't know it.
There's no proof in the pudding that she hit him.
No, there's no proof at all, really. In my mind, although the thing that got me about this comment was this thing right here. The cult members. The cult members. Hey, nobody ever offered me any Kool-Aid. Not that I take it. But number 7, Dita Marzo, 4237. How can any sane judge allow this to continue? Regardless of whether people think Karen Reed is guilty or innocent, the district attorney in Norfolk County, Massachusetts State Police, and Canton Police Department completely screwed up this case. Videos are gone, phones getting destroyed, inverted video, and missing ring videos. This is an M case of a Boston police officer. The Norfolk DA should be fired. Well, you know what I said to this? You can't fire an elected official. I mean, he's elected, and he's up for re-election in 2 years, in actually next year, because it's now 2025. He's up for re-election in 2026, but you can't fire an elected official. I know there might be a certain person in Washington that a lot of people would like to fire, but you can't fire an elected official.
Number 6, Justin Tharp. There's just no good excuse for Hank Brennan not to at least check on something like that beforehand, just to make certain Morrissey is not sending anyone on a wild goose chase. Like you say at the end of all your videos, be kind to others. Well, in the case of the prosecution, I would add, while you're being kind, don't forget to be honest.
That's true.
Yes, but like we said before, unfortunately, they're not going to be honest because they want to nab Karen Reed.
It would appear that way. Here's our feature we do every week. The world is watching. We keep track of all the countries from where we get commenters. And this is just in the Karen Reed case. Countries that have people who watch our episodes and then comment. There are 44. Last week we had 3 new countries, and this week we didn't have any. So if you know somebody who lives in one of these countries that is not on the list, if you know someone that lives in a country that is not on this list, please let them know and have them give us a comment, and we will put them on the list. So Jesselyn says, great video, LOL. Jennings and Santa want to keep everything secret. Bryan wants it all public. No guilty man is going to say, oh yeah, let's bring it all out to the public. He would be agreeing with the state. No more shushing, Ms. Jennings. Ann and team will be eating all for lunch, especially all we learned at last week's hearing. We did a short on this. Maybe we should replay it for our viewers right now.
Yes. I've been going over your coverage of the Kohberger case. How come you always call Ashley Jennings Ashley Hush Jennings?
Ashley Jennings is the senior deputy prosecutor in the Latah County Prosecutor's Office. She was assigned to sit with William Thompson at all of the hearings, and she sits next to him and fulfills the role of a deputy prosecutor.
Yeah, so?
Kohberger's defense attorney, Ann Taylor, had been listing in open court all of the evidence that they claimed had not been turned over by the prosecution.
Things that they have not given us, the drive test information, the verification of...
Wait, what did I just hear?
At that point, Ann Taylor accused prosecutors of not handing over evidence, and she had filed 5 motions to compel.
Oh, I remember.
Now, the court's video is very unclear, but I think their audio is very clear.
Shush.
What did she say there?
She definitely said shush.
Shush.
Why doesn't she shush? Yes.
Okay, so that was quite a thing. I can't believe that didn't get more attention. I can't believe that the fact that there was a shush in one of the hearings didn't get more attention. I've just never seen that ever.
Yeah, it was very inappropriate of her. Number 4, Agape Love 992. Thanks for the content. I agree. The info revealed at the 2 motion hearings certainly changes things. Why did the samples on the banister and gloves not get the attention the touch DNA did? I have a request, Andrew. Could you do an episode on the reason and importance of chain of custody?
Well, I don't know if I want to do a whole episode on it because it might just bore our listeners silly. But chain of custody, the basic idea behind the chain of custody is so that when you get to trial, items that are proffered as evidence are genuine and they are what the attorneys say that they are. Chain of custody says that from the time that whatever item of evidence, it might be a drug sample, it might be a weapon, a gun, or a knife, or anything like that, might be anything, that a chain essentially is established from the moment that the police officer or other investigator first sees it until the time that it's collected, until the time that it may be stored, until the time that it is tested, until the time that it actually comes into court. Every single individual who comes in contact with that item needs to sign on and sign off. So, for example, a sample of maybe some white powder that police see in someone's house. They've got to bag it and tag it in an evidence bag. It looks to the untrained eye like a baggie or something like that, a Ziploc bag. It is sealed in the bag. A tag is put on there identifying where and when it was first observed and collected. And a number or a letter is assigned to it. Then somebody has to transport it. It may not be the original officer, or in a smaller environment, it may be. Someone transports it from the scene of the crime to the law enforcement agency. That person signs off on it. Then it's signed in, usually to a place like an evidence room. It could be something else, but it's signed into the evidence room, and they have lockers. It's called a locker because it locks. Anyhow, they put the item in there, and somebody accepts it. Somebody receives it and signs off on it, the day and the time and the place. It's kept there until perhaps the lab has to go test it. You can't just bring powder into court. It has to be tested as to what it is. And again, this could be any piece of evidence that's collected at a crime scene. So it goes off to the crime scene with the documentation that I've been talking about all along intact. The crime lab accepts the item. They test the item. Anybody who's ever watched any kind of a movie or a CSI or anything on any crime knows that the crime lab goes through a detailed analysis of what they do. I put it in this microscope, or I tested it with this substance, whatever. It's all meticulously and carefully documented until it may go back to law enforcement until the day of the trial when it's brought back. So that's a nutshell. I mean, in law school, you could probably talk for an entire hour and a half lecture about chain of custody. But that's the whole idea, is to be certain that the item that comes into court is authentic and it is what it says what it is, and that someone from the time that it's discovered at the crime scene until it's offered in court has documented where it is, when it is, where it's transported. And the whole theory is to get around any allegations that there's been a plant. If something is just left out on a table, like we have our notes all over the table here. You know, we have my phone's over there, your phone. No, it can't be like that, because somebody could take your phone and plant another one in there. So I don't know. Did I make that clear or not?
Yes, no, you did a good job. No.
Okay. So the next one is, oh, here we go. Another question. Number 3. What is a Frank's hearing? And this is from Loretta Zavala. And in brief, a Frank's hearing tests an affidavit or another document that underlies a warrant to ascertain whether it is truthful, complete, accurate, and doesn't have misstatements, lies, and intentional misstatements. Those elements all need to be proven before you even get a Frank's hearing. The defendant, who usually brings the Frank's motion, has the burden of proof to show that there's a substantial likelihood that these things are untrue. And then the second thing they have to prove is that that would have made a difference in the case. So once they prove all of that, then they get a hearing. And the second step is a hearing. Did all those things actually occur? Are there misstatements of truth that were recklessly made, reckless misstatements of the truth or lies? And again, if all of that is proven, then it's up to the court to determine whether that evidence is excluded as evidence in the trial. So that's the essence. Again, we could spend an entire day talking about Frank's, and I've actually in the past been a member of criminal defense attorney associations in my state, and they do talk about these things at continuing legal education. But the whole idea behind Frank's motion is to test whether the facts in the affidavit are true. And that is a big issue right now in the Kohberger case, because the defense is saying there are misstatements in the affidavit, in the Exhibit A to the probable cause affidavit. So the question is whether they rise to that level and whether the court will even grant a Frank's hearing. So I've been talking a lot. It's your turn.
Okay. At Lily Shaw 9439. Hey, love your streams. I am a UK citizen, so we don't get to hear anything until a case has finished in court. Yes, initially upon an arrest, but never in the courts. I believe it's so the defendant has a fair trial. I find it fascinating that the USA has such strong constitutional rights. That's why I watch the trials. Question: what sort of cases normally have this much secrecy?
Well, it's unusual. As I've said before in other episodes, I think it's unusual that there's the amount of secrecy that we have in this particular case. Usually, the defense wants to have a gag order so that the idea doesn't get out that the guy's guilty. They show him coming in and out of these perp walks that you see on TV. The criminal is always who's really only a suspect at that stage. He's always dragged around in the orange prison garb. And the idea is that the public gets the idea, oh, he's guilty. I know he's well, no. So usually it's the defense that wants to keep stuff secret. But Lily Shaw has made a good point here that here's the prosecution really that wants to keep things as secret as they are. We've had commenters say to us that the public doesn't need to know. You don't need to know anything. Yeah, we do. In the United States Supreme Court case of Nebraska Press Association, the court struck a prior restraint in the manner of a gag order or a non-dissemination order. And the United States Supreme Court said absolutely yes, the public does have the absolute right to know what's going on inside of our courts. Now that is to be balanced against the need constitutionally under the Sixth Amendment for the defendant to get a fair trial. So that's a balancing test. But the court said that anytime you're imposing a gag order or a non-dissemination order, there must be a showing that it's substantially needed and that right to a fair trial is substantially threatened. And so it is unusual for a case of this magnitude. I go all the way back to the Charles Manson case, which, yes, I'm old enough to remember it. And, the Los Angeles police wanted the information to get out, and they got the information out about how horrendous the Tate and LaBianca murders were. And they actually showed evidence of what the Manson girls had painted on the walls, which was just outrageous. And I'm certain that whatever happened in this case that's been kept from all of us, I'm certain that it's outrageous, just like in that case. But in that case, it was all kept hush hush. So that is a really good question that I don't think has been answered. Why, in this case, has there been the amount of secrecy that there has been? So, Courtney, any comments on that one?
I think we've talked about this before. I think that maybe they just want to keep the information to themselves, keep it close to their vest so that they can try and secure a conviction against Bryan Kohberger.
Yeah.
That's all I can think of when I hear of this.
Yeah, a lot of people are on your side and say, yeah, they should keep it all secret.
I mean, I don't think that they should. I think that's just what they prefer to do so that they can try and get a conviction.
I think we saw a little bit of insight into what's going on behind the scenes in that last hearing when Taylor started reading some of what Dylan Mortensen had actually said to law enforcement right after the crimes on November 13th of 2022. And she read what she'd actually said, and then she read what had been transposed and twisted around into the probable cause affidavit. And I think, we're starting to see a little bit like the blood on the handrails and some other things that are starting to leak out. And I think that the courts in Idaho have overreached their boundaries in terms of what they have kept secret. And I don't know. I'd love to see some of the secrecy go away. But number one comment is from Mary Poe. Did I say that right?
Yes.
Mary Poe. Could the family members, if identified, file an amicus brief and argue that use of the DNA violated their privacy? I don't know. Usually amicus briefs are brought in the appeals courts. For example, in the Karen Reed case, that case went up to the Supreme Judicial Court of Massachusetts. And in the Karen Reed case, the American Civil Liberties Union filed an amicus curiae brief. So amicus briefs are generally filed in a appeal. So whether they could file one in this case or not, I really don't think so. So that brings us to the end of our questions that we got from our commenters this week. We always have to remind people that the Idaho Kohberger case is about the 4 victims, and we always have to remember them and their families. Kaylee Goncalves, Madison Mogen, Ethan Chapin, and Xana Kernodle. And their families, I know, are some of them are being quiet, some of them are not being very quiet, but you know that they are all concerned and hoping that the day comes for justice for them, whatever justice means in that case. And some people have commented about why even saying that. Isn't that the goal of the whole thing? Is that we have justice in the end? So, Courtney, I always ask you and put you on the spot at the end. Do you have any closing comments?
I hope that they get justice for the 4 individuals also.
Yeah, it's sad that it's taking so long, but it's really essential. It's really essential that all of these matters be taken care of beforehand. People have different comments about Ann Taylor and what she says and how she says it, but I mean, she's just doing a job. She's just doing a job that under the Constitution is required. So please comment. Please be sure to share with all of your friends. We have just broken the barrier of 12,000 subscribers, and we're going for 100,000. So please share, like, subscribe, do all those things. And thank you very much for being with us, and have a good day.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.